So, our next topic is cognizable and non-cognizable offences. Both have been defined under Code of Criminal Procedure 1973. The cognizable offence has been defined under section 2C of CrPC, which says that it is those kind of offences where a police officer can arrest a person without the order or warrant of a magistrate. Now, if we specifically refer to section 2C of CrPC, which states, and I quote, cognizable offence means an offence for which, and cognizable case means a case in which a police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant, which basically means it divides cognizable offence in two categories, not only to the first schedule but also to any other law for the time being in force. While we deal with cognizable offence, we are being referred to the first schedule of the code to find out whether the offence is a cognizable offence or not, but this is not the case. In this case, in this definition chapter, we will find out that the cognizable offence has been divided into two categories. One is to the first schedule, another one is for the any other law for the time being in force. Why such a requirement is there? We will discuss it in the latter part of the class, but first of all we should understand that cognizable offence is an offence for which a police officer can arrest without warrant, whereas a non-cognizable offence is of such a nature for which a police officer before arresting requires a warrant from the court or magistrate. Now, to understand further, we need to refer to first schedule of the CrPC. Let me take you to the screen. See, here you can see the first schedule is basically divided into two parts. One is part 1, another one is part 2. The part 1 which suggests offences under the Indian Penal Code. That means simply it mentions which kind of offences are cognizable in nature and which kind of offences are non-cognizable in nature. There is no such pecuniary limit of punishment is set, not pecuniary, the cardinal values embodied for distinguishing between a cognizable or non-cognizable offences. It simply mentions which kind of offences are cognizable and which kind of offences are not cognizable. But in part 2, we will find some different case. See, in part 2, it is mentioned that classification of offences against other laws. That means here the legislature has put some values of punishment on the basis of which we can distinguish a cognizable offence from a non-cognizable offence. Like in the case of summons case or warrant case, there is a limit to distinguish between the two, which is a summons case is of such a nature where the offence is punishable with the punishment less than 2 years, and in case of warrant case, the offence, the cases which are punished with more than 2 years. But cognizable case being in a nature where no such punishment is prescribed, simply if it is mentioned in the first schedule as a cognizable offence, then it will mean a cognizable offence, or non-cognizable offence if it is mentioned so in the first schedule. But in case of other laws, there is a limit set by the parliament. What is the limit is 3 years. Here the first category of offences is if punishable with death, imprisonment for life, or imprisonment for more than 7 years, then such offences are called as cognizable offence. Whereas if punishable with imprisonment of 3 years or upwards but not more than 7 years, then also it will be treated as cognizable offence. If the punishment is prescribed under 3 years, then such offences will be termed as a non-cognizable offence. This is only valid for other laws. That means if an offence is punishable with 3 years or more, it will be treated as a cognizable offence, and if an offence is punishable with less than 3 years, it will be called as a non-cognizable offence in case of other laws. This theory is not applicable to the Indian Penal Code. For Indian Penal Code or IPC, the first schedule has defined and prescribed which offences are a cognizable offence and which offences are non-cognizable offence. But for other laws, it is categorically defined that if the offence is punishable with more than 3 years, it will be called as a cognizable offence. If it is punishable with less than 3 years, it will be called as a non-cognizable offence. So that is it. And similarly, on a similar footing, we can distinguish a summons case from a warrant case, where in a summons case, the offence should be punishable with 2 years or less, or in warrant case, the offence punishable with 2 years or more. But for IPC, no such punishment mark is given. The quantum of punishment doesn't play any important role, whereas in other laws, the quantum of punishment plays a very vital role to distinguish a cognizable offence from a non-cognizable offence, which is not seen in cases of IPC offences. The reason being, I will tell you that IPC was framed in the time of Britishers. Britishers framed this IPC with a colonial mindset to rule the citizens, how a sovereign will rule over its citizens when it is framed with a colonial mindset. I will show you an example where you can find the lacunas in IPC which must need to be corrected. If we take for an example section 379, which is punishment for theft. Here it is. Theft. Theft, the punishment for theft is maximum imprisonment for 3 years. Now, it is a cognizable offence. Theft, as we all know, if somebody dishonestly takes away a movable property out of the possession of any other person without his consent, is called as theft. That means even if I steal somebody's even 1 rupee, will be termed as theft, though it will later come in the purview of the Act of Trifle or section 95. That's a secondary thing, but the act committed by other person is definitely a theft, and will be punishable under 379, which is indeed a cognizable offence as per our definitions impounded under 378. Now, moving towards the another aspect of it, section 319, where hurt is being prescribed. For hurt, voluntarily causing hurt, the punishment is prescribed under 323 of IPC. Let us see whether it is a cognizable offence or not. Here section in 323, if somebody causes hurt to any other person, such offences will be termed as a non-cognizable offence. You clearly can predict the colonial mindset of Britishers while framing the IPC. If I steal somebody's even 1 rupee, how trivial the amount may be, I will be still held liable for theft, and which is again a cognizable offence. But if I slap somebody or cause hurt to somebody, it will be treated as a non-cognizable offence, and which suggests that hurt is probably less serious in nature rather than stealing somebody's rupee. It is clearly the reflection of British colonial mindset while framing the IPC. So that is the reason why there is no such limit set for the IPC. The quantum of punishment doesn't play any vital role to distinguish between a cognizable offence or non-cognizable offence, but this is not the case for other laws. For other laws, there is a clear distinction between a cognizable offence or a non-cognizable offence. Now, how to, in present times, how do we deal with such a lacuna? If somehow in near future somebody causes hurt to you and you want to institute a police report on it, you want to institute a case upon him, then we all know that in section 154 there is only the police is bound only to accept the information as to an offence which is cognizable in nature. He is at liberty to refuse you if the offence is falling under non-cognizable head, which will be dealt under section 155 of CrPC. For cognizable offences it is 154, and for non-cognizable offence it is 155. Now, if somebody causes hurt to any other person and being a non-cognizable offence, if that person moves to the police and states his grievance, the police is at liberty to inform him and to guide him to the magistrate instead of receiving his FIR. And there the person cannot force the police officer to register his case. So what to do in this scenario is that we can take the help of section 155 subsection 3 or 4, I guess. Wait a minute. Yes, it is section 155 subsection 4, where it is mentioned that where a case relates to 2 or more offences of which at least one is a cognizable, the case shall be deemed to be a cognizable case, notwithstanding that the other offences are non-cognizable. That means if we add some other complementary, not complementary, some additional offences along with hurt which is cognizable in nature, this will ultimately make our case a cognizable offence, cognizable case rather than a non-cognizable case, for which normally if hurt is caused to somebody, he should add another offence term which is cognizable in nature. For example, wrongful restraint. Wrongful restraint is also a cognizable offence. So what is done here ki apart from 319, if one adds the offence of wrongful confinement, it will technically convert his cognizable offence, his non-cognizable case into a cognizable case. And then by virtue of section 155 subsection 4, the non-cognizable case will automatically convert into a cognizable case, and then the police officer is empowered to receive the information from the informant. So, how such a precarious situation is dealt by applying section 155 subsection 4 to convert a non-cognizable case to a cognizable case. That is the reason why different wordings were being used. First of all, we find that in section 2C we find a cognizable offence, but in section 155 we found section 155 subsection 4 we found it as a cognizable case. So, the basic difference between a cognizable case and a cognizable offence is very simple. The reason being, in a cognizable case there may be a non-cognizable case, whereas in cognizable offence, the offence which is made a cognizable one by virtue of the first schedule. Sorry, my wordings little bit slipped away, no issues. The cognizable offence as per section 2C, we have 2 which is made clear by way of first schedule, but in case of a cognizable case there may be a non-cognizable offence. So,